should know. I have never really liked you at all. I cannot hide it anymore. I've been thinking about the future, trying to forget about the past. So many ways that I could change for the better. Don't even
This is a true crime discussions channel. We speculate. This is all just speculation. Because it's true crime, it's for mature audiences only. There will be no children allowed, no exceptions. Everything on this channel falls under fair use. Please remember to like, comment, subscribe, and share. It's free.
Hey y'all, it's so good to see y'all this Monday. I'm so glad y'all are here. Hello, Abellis, Julie, Amanda, Heathen, Bogart, Southern Cats, Fawny, Kimmy C123, Jenny Jen, LJ, NC Boomer, Joy, Fawny, Ali X, Roxanne, Secret Squirrel, I like that name. Gray Moon, good to see you. Miss Sarah, good to see you. Bad Girl, good to see you. Pamela, I think that's about all I see. Bogart, Joyous N, good to see you. Annabelle, good to see you. Lori and Cracker Jacks, good to see y'all. Ever Love Me, Sandra, Orange Rose, good to see y'all. It's good to see y'all today. Hey, Colonial Forbin, good to see y'all. I'm so glad y'all are here. So I have a couple of Chelsea, good to see you. I have the document, the actual order denying the motion filed by Stephen's attorneys to keep the media out of the courtroom. And so we are going to read over that first, and then we're going to look at discovery. Hey, Blue Sapphire, what do they have against Stephen Stearns? Like, what are discovery is everything basically they're going to use in court. We'll look up the term for what a discovery document is, and we'll talk about that. Hey, Lord Mommy. Okay. So I'm going to read this. I'm going to attempt to read it from my computer. I do not have it printed out. It has been a super busy day. Scratch to paint. Good morning. And so I have not got my stuff together. So let's read this. This was filed March 27th at 2:19 p.m. It is the state of Florida versus Stephen Michael Stearns. It is an order denying defendant's motion for closure of all pretrial proceedings. It reads, this matter is before the court on defendant's motion for closure of all pretrial proceedings filed by and through counsel on February 18th, 2025. After reviewing defendant's motion, the arguments made at the hearing held on March 20th, 2025, the court file and the records, the court finds as follows. In the instant motion, defendant contends that there has been extensive coverage regarding the allegations in this case by television, print, and social media entities, as well as social media users all over the country and world on various platforms such as YouTube, X, Reddit, and Facebook. And over here at Allegedly Speculating. Because defendant expects to pursue multiple motions once discovery is completed that may require testimony and evidence prior to trial that could later be found to be inadmissible, defendant asserts that public dissemination of this evidence during those hearings would prevent him from receiving a fair trial. Counsel for Mr. Stearns further avers that there are no suitable alternative measures to protect Mr. Stearns' right to a fair trial. Consequently, defendant moves this court to enter an order closing all pretrial proceedings. The Florida court's holding in Miami Herald Publishing Company versus Lewis recognized the presumption as that the public should generally have unrestricted access to all judicial proceedings. Miami Herald Publishing versus McIntosh and established the three-prong test to determine whether closure is appropriate and warranted. This test considers whether 1, closure is necessary to prevent all serious and imminent threat to the administration of justice. 2, no alternatives are available other than a change of venue, which would protect the defendant's right to a fair trial. And 3, closure would be effective in protecting the rights of the accused without being broader than necessary to accomplish this purpose. Lewis at 3. As to the first prong, the factors to be considered include the extent of prior hostile publicity, the probability that the issues involved at the pretrial hearing will further aggravate the adverse publicity, and whether traditional judicial techniques to insulate the jury from the consequences of such publicity will eliminate the problem. At 7, after considering the arguments for the parties at a hearing held on March 20th, 2025, The court finds that closure is not necessary to prevent a serious and imminent threat to the administration of justice. Although defendant proved that various news organizations, social media outlets, and individual social media users have posted numerous articles or comments pertaining to this case, defendant failed to establish evidence that the media coverage was fundamentally hostile or that issues involved at all free I'm sorry or that issues involved at all future pretrial hearings will further aggravate adverse publicity. Defendant also failed to establish proof that potential venue members in Osceola County have been exposed to detrimental facts about the case, thus tainting the jury pool from the onset. Furthermore, other alternatives such as multiple venue panels. Hold on just a second. I apologize. Furthermore, other alternatives such as multiple venue panels, voir dire by counsel, and preomptory challenges individual questioning of jurors regarding media exposure, sequestration, and admonishment of the jury are available. Goodness gracious. Hold on. Hold on just a minute. I'm working on it. This one got a little lighter. Okay. Exposure, sequestration, and admonishment of the jury are available in this case to eliminate pretrial publicity concerns. The court is confident that these alternatives will be employed to ensure the defendant receives fair and due process. Finally, the court finds that an order granting defendant's motion to close all pretrial hearings would be overly broad. Defendant has not established that every future pretrial motion and hearing filed and yet to be filed will contain evidence that the public should not have access to. As a result, it would be unnecessarily broad to veil all future pretrial hearings from media coverage or public scrutiny. Based on these findings, the court will endeavor to balance the potentially competing yet fundamental rights to a fair trial and guarantee by the Sixth Amendment the presumption of unrestricted access to public judicial proceedings and the free press granted by the First Amendment without closure. Accordingly, it is hereby ordered and adjudged that defendant's motion for closure of all pretrial proceedings filed by and through counsel on February 18th, 2025 is denied. So they're saying that basically we have freedom of speech and your request is too broad. There's too much covered in it. Like you're not being specific enough about what is going to happen and all of that. Let me pull up this document and then we'll get into a video where I'm reading and I'm not just reading out loud. I wonder what Jen's doing too. Hey, Marley Mom. Oh, I was like, what's going on? You're fluent in Monday talk? I am not. I am not ready for this here day. All right. This is just a notice of hearing, and it was also filed on March 27th, and it says you are notified that the undersigned will appear before the Honorable Keith Karsten, Judge of the above style court on April 23rd at 2 p.m. in courtroom F and in Kissimmee, and it's going to be to go over the motion to suppress evidence obtained from the unlawful seizure of the cell phone, the motion to suppress evidence obtained from the unlawful searches of the cell phone, and the motion to suppress evidence obtained from the Google search warrant. Please be governed accordingly. So, do y'all want to look at these motions that they're going to have the hearing about in April? I can grab that one. We'll grab that video where I'm reading those documents and listen to it and talk about it. So let's start with that, and then we'll talk about discovery. Hold on. I think I've got it in this one. Yep, I do. Okay. So I'm going to grab this. We're going to listen to reading of this document, and then we will talk about it as we read it. And I'll try to pull relative videos so we can hear basically what they're talking about. I do not want to listen to myself talk, so I will this is going to be a long video. It's going to be the documents that I just got. I don't want to hear myself talk, but I will do it because I love y'all. It's supposed to have chapters in it. All right, let me take it back to here.
Yourself without the watermarks to do with whatever.
Oh, it's got
you can find them
the
on
music
my
behind
Patreon,
it,
which
so
will be linked
we'll
below.
have music. This is going to be a long video because there's a 26-page document, a 22-page document, and this first document is 14 pages. So I'm going to go ahead and get started. I will speed it up to 1.25. So these are the 3 motions that they're going to have a hearing on in April. This first documents, obviously, the state of Florida is a plaintiff versus Stephen Michael Stearns, the defendant. It is a motion to suppress evidence obtained from unlawful seizure of cell phone. It reads, comes now the defendant, Stephen Michael Stearns, by and through his undersigned counsel, pursuant to the 4th Amendment to the United States Constitution. Good Lord, I didn't realize I talk so fast. Let me know if that's too fast. Another content creator claimed Jen was seen wearing a hat, taking her dog out, cut her hair, and had lost weight, allegedly. I had heard that. But I don't know. I don't know anybody down there like to verify it, but I have heard that. Amanda just gifted 5 Speculation Station memberships. Thank you so much for that. Those went to Leonore, Borelli, T. Old Girl, Dada, Undead Ramen, and House Music. Thank you so much for that. That was so very sweet and supportive of you. I really appreciate that. Thank you so very much. If you were gifted a membership from Amanda and you are aware you were gifted, please tell them thank you. And I will grab the crazy train and pick y'all up on the way to Speculation Station. I'm going off the rails on a crazy train. Thank you so much, Amanda. That was so very sweet and supportive of you. Hey, Anatolia. Whoop, whoop. Article 1, Section 12 of the Florida Constitution and the Florida Rule of Criminal Procedure 3.190, subsection G, and hereby moves this honorable court to suppress all evidence obtained directly and indirectly from law enforcement's unlawful seizure of his cell phone. As grounds for this motion, the defendant states, introduction. This case presents a flagrant violation of Mr. Stearns' constitutional rights under the 4th Amendment, Article 1, Section 12 of the Florida Constitution. Detective Tangler with Orange County Sheriff's Office ultimately seized Mr. Stearns' cell phone without consent, without a warrant, and without exigent circumstances. The phone was then retained for over 9.5 hours before law enforcement coerced a purported, quote, consent, unquote, for its forensic examination. Because the seizure was unlawful and all evidence obtained bears the taint of this initial illegality, court should suppress the cell phone evidence and all derivative fruits. This motion is filed contemporaneously with related motions to suppress evidence obtained from the unlawful search of Mr. Stearns' phone and evidence obtained through the subsequent Google account warrant that relied. So right now they're saying that everything that they got from the Google Drive, everything they got from the phone, all the CSAM, all the evidence of everything that he had been doing for Maddie over all of that time period, this 5 to 7 years, should be suppressed because they gained his cell phone illegally. Evidence to be suppressed. Any and all tangible evidence obtained contemporaneous to and following the illegal seizure of Stephen Michael Stearns' cell phone. Specifically including but not limited to all data obtained from the subsequent download of the phone, all evidence obtained through execution of the Google warrant, and all derivative evidence and investigative leads developed through exploitation of these constitutional violations. Standing. Stephen Michael Stearns has standing under. Okay, so they're saying that the search basically, again, that everything they gained from the search of the cell phone is illegal. And then everything that happened after that, or because of what they found on the phone, should be dismissed because it was all illegal. I'm going to try to change the background so you can tell like what's the video and what's me actually talking. We'll go with this one. That's a little chill. All right. Under the Fourth Amendment to the United States Constitution and Article 1, Section 12 of the Florida Constitution, as he was the owner and possessor of the cell phone that was illegally seized on February 27 through 28, 2024. Riley versus California establishes that cell phones are entitled to heightened Fourth Amendment protection due to the vast amount of private information they contain. They cite Riley versus California from 2014. Burden on the moving party. The moving party's initial burden has been met through documented evidence of a warrantless seizure in law enforcement reports. Once established that a seizure occurred without a warrant, the burden shifts to the state to prove an exception applies. They cite Norman versus State from 1980. While I flip this page, if you guys want to see us talking about these documents and basically stating what we thought about it, you can do so in the live stream with this thumbnail. Statement of facts. 1. On February 26, 2024, at approximately 2000 hours, Jennifer Soto. So I'm going to slow this down because this is kind of important. It's basically the facts and why they're saying the seizure of the cell phone was illegal. Now, he was asked several times, to give up his cell phone. Was that okay? Do they care? Does he care if they look through his cell phone? All of the things like that. And what they're saying is that the way he was presented that question, he wasn't given much of a choice in the matter. So I put this on normal speed while we listen to the statement of facts. Her 13-year-old daughter, Madeline Soto, missing to the Orange County Sheriff's Office. 2. On February 27th, by Miss Soto and Mr. Stearns. 3. Detective Tangler of the Orange County Sheriff's Office was assigned as lead investigator. 4. On February 27, 2024, at approximately 1600 hours, Detective Tangler, accompanied by Detective Acosta, contacted Mr. Stearns at his residence. 5. The detective's interactions with Mr. Stearns were audio recorded and captured the exchanges between law enforcement and Mr. Stearns. 6. Mr. Stearns' residence is located at the address. 7. Detective Tangler sought limited access to Mr. Stearns' cell phone, specifically requesting only to check his Google login status by asking, quote, "Is it okay if I go in your settings real quick? I just want to see if you're logged onto your Google," unquote. Okay, that's important. Do you guys remember what she said? I just want to see if you're logged into your Google. Like, do you care if I go in your settings? Because I'm looking at your map and I'm looking at your call history and your text messages, and there's nothing here. So it appears that you don't use this phone. So do you care if I go in and look at your maps real quick? And Stephen says, sure, that should be fine. Okay. Right. 8. You gotta remember that. Like, she had permission to do that, and they're saying she didn't have permission to do any of the rest. Mr. Stearns responded, quote, "Yeah," unquote, to this specific and limited request. 9. After exceeding the scope of this limited consent, Detective Tangler unilaterally announced, quote, "I'm going to hold on to your phone," unquote, and, quote, "I'll give it back to you when we're done," unquote. 10. Mr. Stearns expressed explicit concern about maintaining contact with his father through that phone. 11. Detective Tangler dismissed Mr. Stearns' concerns by stating they could call Miss Soto's phone instead. 12. Mr. Stearns was given no choice regarding the seizure of his phone. 13. No consent was sought for the seizure of the phone. 14. Law enforcement made no attempt to obtain a search warrant for the phone despite having ample time to do so. 15. The detectives. So Orange Rose said, "I was originally scared about this part, but it seems that the defense wrote it in a very misleading way. Every interview with Stephen, they talk about him voluntarily giving up his phone." Yep. So I think these motions are going to be denied too, but we're gonna listen to it so that we know what they're going to talk about this month. Well, it will technically be next month, as today is the 31st, but in about 20 days. Blue Sapphire said, "I didn't hear any threat towards Mama's boy to hand over his phone. I only heard regret later." Yep. And we have all of the audio interviews to hear that. Jenny Jen said she actually asked him if she could take a picture of his phone and call history before, I believe, I believe before asking about Google. Yep. I do believe that to be true as well. This whole dad and son phone thing is raising my heckles and freezing my cockles. Oh my goodness. Oh my goodness, Phony. And then Boomer said, don't know, Phony, this info from SE based on phone conversation they had on the phone. Yeah, I've seen a couple of things that from another couple of creators that we can discuss too if you guys would like. Did not present Mr. Stearns with a written consent
Smile.
form
Good to see
for
you.
the seizure.
Andy, good to see you.
16. The detectives did not advise Mr. Stearns of his right to refuse consent. 17. The detectives did not provide Mr. Stearns with any documentation regarding the seizure of his phone. 8. So they didn't provide it with any documentation because they got his phone and they didn't. As soon as they found out what was on it, he was arrested. And if an officer approached you and said, "I need your phone because your child is missing," but you have the right to refuse. I just want you to know that. How many phones do you think they'd be getting? Not very many. And how many cases do you think they would in turn be solving? Not very many. Roxanne said, it makes me laugh to know he thought he was smarter than law enforcement, erasing the phone, but not the cloud. Laughing my ass off. I agree. I'm happy about that. 18. The detectives did not document any exigent circumstances justifying the warrantless seizure. 19. On February 28, 2024, at approximately 1:30, detectives again contacted Mr. Stearns. 20. The second contact occurred approximately 9 hours and 30 minutes after initial seizure of his phone. 21. During this midnight contact, detectives referenced their earlier unauthorized seizure, stating, quote, "I told you that I was going to hold on to it and that we would like to download your phone, right?" Unquote. 22. The detectives presented Mr. Stearns with an ultimatum. Quote, "Is this something I have your consent to do, or do I need to get a search warrant for your phone?" Unquote. 23. At the time of this midnight interaction, Mr. Stearns had been detained outside in 50 to 60 degree temperatures. 24. Now, I would think exigent circumstances would be the fact that Madeline was missing. And I would love to know. I mean, I think they found out where her body was because of the flat tire witnesses. But if they got any of that information from his phone and this motion is not denied, then they have to, basically, the fact that they found her body would have to be erased. So let's say that they got his phone illegally, even though we don't think they did. And everything they got from it would then have to be thrown out, which means all of the photos and pictures of Maddie, all of the CSAM except for what was on the USB drive, everything about where he went in the car when he was not tracked on the traffic cameras. Like, they could use their traffic cameras, but if they have him like through GPS on his car or tracking his infotainment system, because they did do a search warrant for that, then they would have to prove that they found Madeline's body by some other means. And if they couldn't prove that they found Maddie by some other means, then there would be no case for even the homicide. CSAM case would be thrown out. Homicide case would be thrown out. All of these things could happen if they say that the phone was obtained illegally. Yeah, please don't forget to hit the thumbs up, and I really appreciate it, you guys. Hey, Mommy Ball. Hey, Sarah A. Mr. Stearns was wearing only flip-flops, khaki pants, and a thin hoodie. 25. Mr. Stearns had not eaten all day prior to the incident. 26. Mr. Stearns was not allowed to return to Miss Soto's vehicle, which was heated despite cold weather conditions. So now they're saying it was cold, he was hungry, and you wouldn't let him sit down or eat or do anything while he was standing out there and made these decisions. So they're going to say he was in a poor state of mind when he made the decision to let them look at his phone. Lisa said they didn't have a search warrant for his phone, never got one to this day, I believe. He agreed to look at Google geolocation only at that time, and then they approached him later and they stated, do I have permission to search through your phone, or do I need to get a warrant for that? And to be fair, I mean, it does make it seem like he doesn't have any other choice. But at the same time, if you were to tell a defendant or a suspect, you can always, deny this, and I'll just have to, I mean, she did say I'll have to get a search warrant, but it kind of makes it seem like, either you can give it to me or I'll just get a search warrant and get it that way, which is factual, but like, you can't being a police officer, it would not benefit you at all to be like, you have the option to say no. I just want you to know that, like reiterating it. So I don't know. Considering that they denied the motion to throw the media out, I'm hoping that they deny these motions as well. Hey, Chris. 27. Earlier that night, Mr. Stearns had taken an Ativan, a prescription medication to manage his panic attacks. 28. Mr. Stearns clarified to authorities that he had taken the tranquilizers to help him sleep, as he had been struggling with insomnia. So yeah, I'm that girl. I'm hoping that they would be able to use that if this gets granted. The fact that they can say they found Maddie from where the flat tire witnesses are, and thank God for that, right? But if they weren't there, like, and they had used like something on his car, or they tracked his car or something like that, if they had like GPS on his car, then they could use that too. But if they were using like his phone or something in the car, then that would be an issue if this order got granted. Considering the fact that the flat tire witnesses were there, I think they would still be safe, but the whole CSAM trial would be thrown out. And in a different case, if they had used just that person's phone or the infotainment system in the car to find the location of a body, that would have to be thrown out too. But at the same time, I would think that the judge is not going to grant an order that like throws out a whole CSAM trial, especially considering how many times they asked for that phone and he said, yeah, go ahead. 29. Ativan is a prescription sedative commonly used to treat anxiety and panic disorders. 30. Ativan is known to cause drowsiness and sedation and impaired alertness. 31. Mr. Stearns described the effects of Ativan to law enforcement, stating, right, quote, this is why I missed your calls. I'm sorry. Took an Ativan and conked out for a few hours, unquote. 32. At approximately 2:40 on February 28, 2024, Mr. Stearns' phone was taken to the Orange County Sheriff's Office Digital Forensic Unit. Legal argument. A. The warrantless seizure of Mr. Stearns' cell phone was unconstitutional. The Fourth Amendment protects against unreasonable seizures of property, even when no search has taken place. United States versus Place from 1983 is what they state. A, quote, seizure, unquote, of property occurs when there is some meaningful interference with an individual's possessory interest in that property. They cite United States versus Jackson from 1984. The instant matter presents precisely such a meaningful interference as Detective Tangler unilaterally seized and retained Mr. Stearns' cell phone for over 9 hours without consent or probable cause. Now that she had it for over 9 hours could hurt them in the end. I don't know. Without consent or trying to get a warrant, but I mean, technically, it appears through all the interviews that we've listened to, he gave consent, in my opinion. This is Sarah said, why would he not eat all day but pop pills? Good question. I mean, good point. I am going to drop the link if anybody wants to come up, since we're just perusing through some of these documents. And we don't have to listen to this whole video. We can listen to just this first document if y'all want to, and then go to the discovery, because, I mean, they're pretty much the same thing. One says unlawful search, one says unlawful seizure. So it's pretty much listing the same things. The Florida Supreme Court has consistently held that Article 1, Section 12 of the Florida Constitution is coextensive with Fourth Amendment jurisprudence. They cite State versus Hernandez from 1998. While law enforcement may temporarily seize property to prevent destruction of evidence while seeking a warrant, so yeah, they didn't get a warrant because they didn't deem it necessary, because he handed over the phone and gave them the PIN. But now they're trying to combat everything. Like a lot of people have said, they're throwing spaghetti at the wall to see what sticks. Yeah, he was eating at night with insomnia. That's right. He doesn't get to take back consent on the phone because he forgot about the cloud or thought Ellie wouldn't be that thorough. Right. Hey, Cajun. Good to see you. Ellie X says he doesn't look like he was missing any meals. No doubt. Bad girl, I hope you're okay. If you need to email me, you can. Orange Rose said, I'm guessing we're going to see the judge's snarky face on this one. Yeah, I hope so. It should be televised. Seizures must be, quote, properly limited in scope, unquote. They cite place. The United States Supreme Court has emphasized that courts must consider, quote, the length of the detention, unquote, in determining whether a seizure is reasonable. The Supreme Court held in place that even when supported by reasonable suspicion, a 90-minute detention of property was unreasonable. Here, the 9.5-hour seizure, unsupported by any reasonable suspicion, grossly exceeded the temporal limits deemed reasonable in place. The Florida Supreme Court analysis in Golphin versus State further illuminates why the seizure here was unconstitutional. Golphin versus State from 2006, what they cite. In Golphin, the court examined whether retention of identification during a brief warrants check constituted a seizure, emphasizing that, quote, not all encounters between law enforcement and individual citizens constitute seizures, unquote, but rather courts must examine the totality of circumstances to determine if there was meaningful interference with possessory interest. Unlike Golphin, where officers merely retained identification briefly during a consensual encounter, Detective Tangler effected a full seizure by unilaterally announcing that she was taking possession. So they cite a case where the police took this man's identification for a short amount of time that was consensual. There was some kind of court case held about that instance, and they're saying, you know, that court case, it was found to be that they held his documentation unlawfully, even though it was just for a few minutes and it was consensual. And they're saying in this case, they held it for over 9 hours without having a search warrant. And Stephen Stearns felt like he didn't have a choice in the matter. Fawny said, remember, we want a good lawyer for Stephen, because a case getting thrown out would be, I can't even think it, let alone type it. Yeah, I've heard that it's actually good that she's throwing all of these motions at the wall to kind of see what sticks. Considering, like, when you take into account appeals processes, you can appeal and say I had ineffective counsel. And so if he was trying to appeal the decision that is made on the CSAM trial or the homicide trial, it's going to be hard for him to say that he had ineffective counsel. I mean, I know you can appeal for a number of reasons, but that one specifically would be null and void because she is trying everything without seeking consent, retaining it for over 9 hours, and completely depriving Mr. Stearns of his ability to communicate with family members. The extended duration and complete deprivation of Mr. Stearns' possessory interest in his phone, holding that even brief I don't know why it's doing that today. Investigative detentions of property must be properly limited in scope and duration. Detective Tangler made no attempt to obtain a warrant, despite the availability of an emergency duty judge system and ample time to do so during the initial. Now that makes me a little nervous because I reckon I'm gonna have to put it back on normal speed to get it to quit skipping like that. But it makes me nervous because they do have the ability, like there is a magistrate on call at all 24/7. Right. So she could have called the magistrate at any time and got a search warrant. But again, I mean, you can even listen to the audio interviews that go with this that have been given freely to the public through FOIA requests and see that it appears he gave it to them willingly. And if he wasn't asked so many times in so many different interviews, specifically about the phone and permission to go through it, I think I'd be a little bit more nervous. I mean, there are some things that made me nervous about this, because she feels like she's possibly got a case or she wouldn't be filing the motion. You know, they're not filing a motion that to have a ham sandwich thrown out because he ate it. You know what I mean? Like it fits the case. It fits some aspect of the case or she wouldn't be filing it. But again, I mean, I think she's just trying everything and I don't think that it's going to apply. I hope not. Sandra said, without a conviction, the SA case, they have no case for the death penalty. Exactly. So that's one of the reasons why I'm so nervous. Well, if law enforcement would have just gotten a warrant, this wouldn't be an issue, right? But I think that their thought process was that he's already deleted all of this stuff, unless they stood there and waited for a warrant to come, which, again, they probably should have done. There was a possibility of them losing more evidence. And that presents extingent circumstances as well, because they can say, well, obviously he had already deleted all his call history, all his Google Maps and all of that. So obviously, you know, there's an extingent circumstance that if I give this phone back to him, he's going to delete more evidence. So we had to do it this way instead of waiting for a search warrant. However, she could have asked him and had someone simultaneously go get a search warrant. You know, I mean, there's you can look at it from both sides. You know what I mean? Blue Sapphire said the best recent argument for proof of media exposure that included a TV documentary did not sway the jury of the roommate homicide trial. Interesting. Oh, look, a squirrel. Said, isn't this the same prosecutor from Sarah Boone? Because that toss the phone attempt failed and Boss Hog judge wrote a hella decision. Yes, I do believe William J. I know William J. is the prosecutor on this. I'm pretty sure. I've read some of his stuff. And I scrolled down. Flora W. said it just freaks me out. He thinks his parents should set up a trust fund for him to take care of him. Right, but when you're in prison or jail and you have no way of making money other than being a trustee and getting paid probably pennies a day, they're trying to make sure he has what he needs. I mean, considering that they supported him his whole entire life and every endeavor he ever wanted to do, they're not going to stop now. The initial seizure. Instead, that's where I'm at. Detective Tangler retained the phone for over 9.5 hours without providing any indication of when or how it would be returned, far exceeding any reasonable scope or duration under Fourth Amendment jurisprudence. The length in detention alone precludes any argument that this was a properly limited investigative detention under Place and its progeny. 1. So they're saying it was limited to the search of the Google Maps. Oh, yeah. After he's deceased, I'm sure he expects an inheritance, and they're going to give it to him. Pennies a day for 40 years will be enough to get started. Right? Yeah, she said slush fund. I know that for sure. Can you tell me what a slush fund is instead of a trust fund? I thought it was the same thing, but she definitely said slush fund, not trust fund. We can look it up if we need to. The initial seizure exceeded the scope of any purported consent. Hey, Sunshine. While consent provides an exception to the Fourth Amendment's warrant requirement, such consent is strictly circumscribed by its express scope and circumstances. They cite Florida versus Gimeno from 1991. The United States Supreme Court has established that the standard for measuring scope of consent is one of objective reasonableness. Now, this case cited specifically is out of Florida, so it does make me concerned because she's citing these cases, saying in these cases it was ruled out of the scope, it was ruled impermissible, what they did was wrong, and it was ruled that way. And this one specifically is out of Florida, where they are. Florida seems to be a little bit more like, I don't know, in my opinion solely, like they're going to get their person, the defendant, they're going to get their guy. You know what I mean? So like for it to be out of Florida made me a little concerned. Specifically, quote, what would the typical reasonable person have understood by the exchange between the officer and the suspect, unquote. This objective standard protects against law enforcement's unilateral expansion of narrowly granted permissions into broad investigative authority. Florida courts have consistently enforced strict limitations on the scope of consent, recognizing that permissions granted for one limited purpose cannot justify broader government intrusion. In Appellate versus State, the 5th District Court of Appeal held that consent to enter a home to check on well-being did not authorize a full search of the premises. And Appellate versus State from 2015 is what they cite. Similarly, in State versus Wells, the Florida Supreme Court determined that consent to search a car trunk did not extend to closed containers within that trunk. And they cite State versus Wells for 1989. So they're saying in that one, basically they asked for consent to search a trunk, but then they went inside bins that were in the trunk and found some things and held that man accountable. And it was later ruled that because they only asked to search the trunk and not the things in the trunk, not the stuff that was in the container, that it was unlawful. So basically how they're relating that to Stearns is by saying you asked to search the Google Maps and his call history, not go into the Google Drive. So it's like they're making you look at it like the phone is the trunk, right? And you're asking to look at maps and phones or what's in the trunk, and you went into another box in the trunk or the Google Drive in the phone. Like you had to go somewhere else on the phone to pull that up and go through it. Zan said slush fund money he can use whenever. Trust fund money use with limitations and outside management. Thank you, for that. I appreciate you illuminating us on that. The decisions reflect the bedrock principle that law enforcement may not exceed the reasonable scope of specifically granted consent. In this instant case, Mr. Stearns provided extremely limited consent for Detective Tangler to, quote, go in your settings real quick, unquote, solely to, quote, see if you're logged onto your Google, unquote. No reasonable person would understand this narrow permission to check a single phone setting as consent to a complete seizure and 9.5 hour retention of this device. So again, they're referencing what she said, and we can pull that up in the interviews. Oh, look, a squirrel. Oh, look, a squirrel. Said, stuff on the cloud is recoverable. I think even if harder scanning a person's cloud is basically standard practice now. They already had him in their sites. Inevitable discovery applies. So I don't know what inevitable discovery is. Let's see what that is. Are you saying like he was going to be discovered inevitably, I would assume? INEVATABLE. I mean, I'm assuming that's what you're saying, but I was going to look it up and see if there is a definition. The inevitable discovery doctrine is a legal exception to the exclusionary rule, allowing illegally obtained evidence to be admitted if the prosecution can prove the evidence would have been discovered lawfully regardless of the misconduct. Okay. I mean, I think that's good. Can we prove that we would know that Madeline had been abused without the phone evidence? And then if we take into account the fact that Chris Stearns gave him the USB drive and that had all the stuff and that was not included in his Google Cloud account and all of that, I mean, you would automatically say, okay, well, if he's got a USB drive with all the CSAM on it, what could he have been doing with Maddie and found it out that way? Yeah, I'm assuming. So yeah, I think it would apply. Yeah. Basil's here. I got to put him on the bed. Hold on. Detective Tangler's unilateral announcement that she was, quote, going to hold onto your phone, unquote, and subsequent extended seizure far exceeded any reasonable interpretation of Mr. Stearns' limited consent. This expansion of authority mirrors the impermissible scope extensions rejected in both Appellate and Wells. Just as consent to look in the trunk does not permit searching closed containers, permission to check a single phone setting cannot justify a prolonged seizure of the entire device. And that's what I was just talking about when I related it to his phone to like a trunk, and then like the Google Drive that they found all the stuff in would be like a box in a container with a lid on it in the trunk. Oh, look, a squirrel said they were looking for a missing child that opens all doors. You would think. But if they come back and say, well, technically, even though you found those things on the phone, it did not lead to the discovery of Madeline's body, it could cause some issues. Flora W said, even freaking Chris Watts has a prison job. You know, Stephen going to be needing his root beer barrels and saltines. No doubt. I don't know. So, okay. Well, let's talk about that. Southern Cat said, I don't think the USB drive can be used in court. So the USB drive came from Chris, which is a relative of Stephen. Could they might have an issue proving in court that it was indeed Stephen's and not like Chris's or somebody else's. That would be the issue with the USB drive. But if they could prove that it was indeed Stephen's, then they could rightfully so say, well, if he's got this USB drive, what's on his phone, we need that. So I don't know. That's a good point. There would be some motion filed to try to figure that out. Marley Mom said, I thought it was a hard drive. So is there a difference between the two? I'm not technically inclined. So a USB drive is a very small, I've got one now in my computer, actually. It's like smaller than a lighter. And then a hard drive is like a square. It's like the size of a CD almost, or they used to be. I don't know. They might look different now. It's been a long time since I've seen one. The unreasonableness of interpreting such limited consent to authorize extended seizure is particularly apparent given the Supreme Court's emphasis in place that even brief investigative detentions of personal property must be strictly limited in scope and duration. They cite place again. When Detective Tangler exceeded the bounds of consent by unilaterally seizing the phone, she needed independent constitutional justification for that expanded intrusion. No such justification existed, rendering the extended seizure unconstitutional under both consent and general Fourth Amendment. Hold on a minute. I missed that because I was talking. I'm going to take it back just a little bit. I'm not going to do this whole video. We're just going to listen to this one document. And then we'll talk about discovery. But I wanted to see what that last part she said was. So I'm going to play that again real quick. Mentions of personal property must be strictly limited in scope and duration. They cite place again. When Detective Tangler exceeded the bounds of consent by unilaterally seizing the phone, she needed independent constitutional justification for that expanded intrusion. No such justification existed, rendering the extended seizure unconstitutional under both consent and general Fourth Amendment principles. So basically, they're saying she needed a reason. She needed to cite a reason for wanting to search the Google Drive, and that didn't happen. And there was no exigent circumstances, but you could say, well, there's a missing child, and then they would come back with, well, what does that have to do with his Google Drive? Like, you're not going to find anything on his Google Drive. If you're looking for a missing child, that would relate specifically to his Google Maps or GPS or phone call history, which is what you originally asked to look for. There is no reason to search through his Google Drive looking for a missing child, would be my thought on that. Number 2, no exigent circumstances justified the extended seizure. While law enforcement may conduct a warrantless seizure when exigent circumstances exist, such circumstances are, quote, few in number and carefully delineated, unquote. They cite Welsh versus Wisconsin from 1984. The state bears the burden of demonstrating that the procurement of a warrant was not feasible because, quote, the exigencies of the situations made that course imperative, unquote. So it's the prosecution's job to say, basically, we couldn't get a search warrant because we didn't have time. Can they say that? I think so, personally, because he had already erased all of his Google Maps, all of his call history, and all of that. So they could definitely say, in my opinion, that it was possible that we were going to lose evidence if we didn't do it the way we did. Now, holding it for 9 hours and not receiving a warrant during any point during that 9-hour period could hurt them. But I think that they could definitely say that, it was obvious he was deleting things and we needed to make sure that didn't happen. Matilda said, no reason. A grown man sleeping with a child before she went missing is a reason. And it absolutely is. It's a reason for him to be electrocuted this here day right now, in my opinion. But they wouldn't know that if they hadn't gotten the Google Drive. And they're saying basically they did that illegally. Flora said, well, they got a bunch of them and proved whose they were in Rex Heuermann case. They hit his list. I've been following that case, and I've done, I think, a couple of lives on him, but that case is really interesting. Stearns is in protective custody, Blue Sapphire. Crackerjack said, why didn't they obtain written consent for the most important evidence found? I mean, again, I have to agree, but they did get it orally through a lot of interviews later. But I mean, if they had gotten written consent, we wouldn't even be looking at these motions right now. They cite Coolidge versus New Hampshire from 1971. None of the recognized exigent circumstances existed here. First, there was no, quote, hot pursuit, quote, of a fleeing suspect that would justify the warrantless seizure. See United States versus Santana from 19. So now they're going to tell us that there was basically why there was no exigent circumstances. And they say, firstly, he's not going to run away, even though he was driving for hours, all hours of the night, all over the state of Florida. They're saying that he wasn't going to flee, or we're not pursuing him. We're not hot pursuit, like a car chase or something like that. 1976. Mr. Stearns was at his residence and fully cooperative with law enforcement when Detective Tangler seized his phone. He made no attempt to flee or evade the officers. Second, there was no imminent destruction of evidence. See Kentucky versus King. They cite Kentucky versus King from 2011. Detective Tangler articulated no specific facts suggesting Mr. Stearns was attempting to or about to delete data from his phone. Indeed, the phone had already been factory reset prior to the seizure, undermining any claim that immediate warrantless seizure was necessary to prevent the destruction of evidence. Now, considering that he had done 2 factory resets at this time, I mean, if evidence could have been destroyed, you would assume that it would be destroyed at that time. So they might have an issue with that, saying that, well, he had obviously, like I've been saying throughout the live, he obviously deleted the maps and the phone history and all of that. They're going to say, well, I mean, matter of fact, he had done a factory reset, but he wasn't able to delete the evidence you obtained. So obviously that wasn't going to get rid of things that you could go back and get later anyway. And that might be an issue. Florida said they did know he slept with the child because Jen sent them up to bed together. Right. But they didn't know that she was being abused at that point in time. I mean, it's not that hard to put 2 and 2 together, but they have to show evidence legally pointing to that. And yeah, that's another thing for me. Isn't resetting a phone conscience of guilt? It made him look guilty AF. But again, if you've got a suspect and you think he's guilty of something, why wouldn't you go get a search warrant to make sure all your I's are dotted and T's crossed? The mere possibility that additional evidence could be deleted is insufficient to create exigency, as this would effectively eliminate the warrant requirement for all cell phones. They cite Riley versus California. Now, if he had been able to access the Google Drive and delete it like it appeared he was trying to do when he went down to his dad's house and connected to the internet, would he have been able to delete that and clear the history is the question, because we know that he was attempting to do that, but it seems like he was never able to quite get it done. Is it possible to delete your Google Drive history, and is that recoverable? Would be another question, because if they can go in and say, well, if he had been able to delete the Google Drive history, we wouldn't have been able to recover it. So thank God we got the phone when we did, then that's going to be used against the defense in this motion. But if they can go back days, hours, weeks, months, however long later and say, no, even though it's deleted, we could still recover everything, not just what was on the phone, but the Google Drive, all of the things, then they're going to again say, well, there was no reason for you to take it at that moment in time and never get a search warrant. Let me see what y'all are saying. Blue Sapphire says the closest to victims always are looked at first. No way his phone wouldn't be searched eventually. Still can't help but be frustrated with the sloppy procedures. Right. I wish they would have gotten a written warrant. Absolutely. I factory reset my phone when it messed up, but Verizon had to talk me through it. Yeah, it's not an easy thing to do. USB drives are allowed in court as long as the data is correctly preserved. I honestly don't think the things his defense attorney is stipulating will be granted. Everything was done by the book. I hope so. I mean, it seems like when you listen to the interviews and they ask him several times and he agrees several times, it does appear that things were done by the book. Florida says she no doubt thought his was clean too, and that's why she handed it over. People who use Apple don't usually use Google Drive. And I'm wondering if she was involved or knew about it, how all that information was erased. Factory reset a new phone that he didn't take with him all morning after dropping off Maddie to school. Sounds sketchy in my opinion. Yep. He didn't have his phone with him all day and claimed he forgot it. Maddie forgot it. All of these are good reasons in my opinion, but still maybe get a search warrant. No cap, the corruption in the Trump trial makes me more angry that someone with my name did dirty, not the impropriety, which is still bad, but okay. I assume you were talking to someone else. They would have to subpoena Google records. So I would assume they would still be able to get that even after he had tried to delete it, but I don't know personally. Orange Rose says Stephen Stearns obviously has never seen Breaking Bad. Magnets. I haven't heard of that, but yeah, I've heard. Well, I'm assuming you're talking about putting a kind of magnet to a device or a phone or something. Maybe. I don't know. California from 2014. Whereas here, any purported destruction of evidence had already occurred. Law enforcement cannot justify a warrantless seizure based on preventing what has already happened. Third, no emergency aid circumstances existed. They cite Brigham City versus Stewart from 2006. The state will likely argue that the missing child investigation created emergency circumstances justifying the warrantless seizure under the emergency aid doctrine. And they cite again Brigham City versus Stewart from 2006. This argument fails. The emergency aid exception requires law enforcement to have an objectively reasonable bias to believe that an emergency exists, requiring immediate action to prevent imminent harm. They cite Missouri versus McNeely from 2013. While the underlying missing person investigation was undoubtedly serious, the circumstances here do not justify a 9.5 hour warrantless seizure. The timeline itself negates any claim of emergency requiring immediate warrantless action. The child was reported missing at 2000 hours on February 26, yet Detective Tangler did not seize the phone until 1600. This significant delay undermines any argument that immediate warrantless seizure was, quote, imperative, unquote. They cite. Okay, so she's saying because it was about 24 hours later or however many hours later after Madeline had disappeared, there was no reason for them to say basically the fact that that there was a missing child, it should be used as exigent circumstances, as basically circumstances to say, I need the phone immediately to help find this child. But they weren't looking at him. I mean, it took them time to gather evidence to look at him. It took them time to put the things together. Like he forgot his phone, Madeline forgot his phone, and then all of these weird things are happening that make them say, okay, maybe there is something on this phone that we need to see to locate this child. Like you can't just say, even though there's a missing child, because it had been several hours since the child had been reported missing, and the time you asked for the phone, it's not an exigent circumstance. At the time, the child was still missing, and we were not aware that the homicide had been committed. So I think that that doesn't hold up, in my opinion. You do the @ symbol and then type their name. Hey, Barrow and Jenny B. Yeah, I agree. That's kind of what we're talking about, Lil Red, that they should have got a warrant. Like McKinney versus Arizona from 1978. If officers genuinely believed emergency access to the phone was necessary, they could have and should have acted much sooner. Even assuming, arguendo, that emergency circumstances initially justified seizing the phone, this would not excuse the failure to obtain a warrant during the subsequent 9.5 hours of possession. The feared medical emergency exception to the warrant requirement permits police to enter and investigate private premises to preserve life or render first aid, provided they do not enter with an accompanying intent either to arrest or search. They cite State versus Foltz from 2016. Detective Zan said a child missing requires immediate action, whether in the first hour or the 25th hour. That's where I'm at with it, and I think that's where the court will be at with it too, hopefully. Carolina said, yes, our phone can be recovered. Our devices have backup storage in places we can't even imagine. I giggle because people who commit crimes use their phones, like Sarah Boone's, and shop at Walmart. Jenny Jen said, yep, talking about the motion to suppress the phone evidence, hearing for that motion will be April 23rd at 2 p.m. Yes. And then we're going to jump into discovery after we listen to this motion. There's 3 in this video, and all 3 are up for discussion on April 23rd. Tangler's own statements reveal investigatory purpose behind the seizure, as she explicitly told Mr. Stearns, quote, I told you I was going to hold on to it and that we would like to download your phone, right? Unquote. Demonstrating from the onset that her intent was to conduct a forensic search rather than address any emergency. Once the phone was secured, any emergency justification for the warrantless seizure dissipated, and officers were required to obtain a warrant for continued possession and examination. So basically, she's saying that even though they secured the phone, but they never got a search warrant, so they should have secured the phone, waited until they got a search warrant, and then done the deep dive. Which, I mean, probably, yeah. Cajun Juju said he gave them his phone. The lady asked and he gave it. That should be enough. I wish. I hope it is. Didn't Stearns give permission several times? Yes, he did, but they're saying that basically he felt like he didn't have a choice and he was not in the right state of mind and all of that. We're listening to this one document again because we're going to have a hearing about it on April 23rd. The neighboring county law enforcement found the connection from my file from 5 years ago. Oh, wow. That's interesting, Genevieve. It's good to see you. I think they're filming. I think we'll be able to see the April 23rd hearing. I don't know. I don't know if Stearns will be there because it's on motions that his lawyer filed, but we'll see. Their failure to do so, despite the availability of an emergency duty judge, demonstrates that true emergency circumstances did not exist. Detective Tangler's own actions belie any claim of emergency. After seizing the phone, the detective made no immediate attempt to search it or obtain emergency judicial authorization. Instead, law enforcement simply held it for over 9.5 hours before seeking consent for a forensic examination. If they held it for 9.5 hours before seeking consent for a forensic examination, I mean, again, I'd have to say somebody should have gotten a search warrant during that time period. Behavior is inconsistent with a true emergency requiring immediate warrantless action to prevent harm. For a warrantless seizure to be justified under the emergency exception, quote, the person making entry must have had an objectively reasonable belief that an emergency existed that required immediate entry to render assistance or prevent harm to persons or property within, unquote. They cite United States versus Moss from 1992. This objectively reasonable belief must be based on specific, articulable facts and reasonable inferences that could have been drawn therefrom. They cite Mora versus City of Gaithersburg from 2008 and also cite Terry versus Ohio from 1968. Here, Detective Tangler failed to articulate any specific facts suggesting why the extended warrantless seizure of the phone was necessary to prevent imminent harm. The extended timeline, failure to pursue available warrant procedures, and law enforcement's own conduct all demonstrate the absence of an. So they're saying because she didn't give a specific reason for holding his phone for that long without a warrant, it's an issue. Cajun said defense is just throwing crap to prolong, in my opinion. Lil Red said, I'm so glad the judge did not remove cameras from motion hearings. Me too. Orange Rose said it's tricky because you don't need physical possession of the phone to delete things and etc. So I don't know what the law is, but it seems reasonable for police to seize and download as soon as possible. I agree with you 100% on that. Flora said, in my opinion, the female cop asked him a few times and they asked him in that room where they took his clothes off too. That was verbal consent without coercion. I agree, and I hope that it holds up in court. Lori said, I think it was because Detective Tangler asked to look at Google, but went in to check his call list and didn't say that to Stefan. That is exactly what the reason is. Yes, ma'am, you are right. She asked to look at the Google Maps and the call logs and did not ask to look at the Google Drive where she found all the images of Madeline. So, and they didn't have a warrant and he didn't give permission specifically for the Google Drive. So that's what they're saying in court, basically. An objectively reasonable belief in an emergency requiring an immediate warrantless seizure of the phone. Fourth, there were no, quote, community caretaking, quote, circumstances requiring immediate action. They cite Caddy versus Dombrowski from 1973. The phone itself posed no I hate that it rather than for community protection purposes. I hate that it pauses like that when I try to speed it up. There were no exigent circumstances related to officer safety. They cite Maryland versus Bowie from 1990. The phone posted no threat to officer safety, and Mr. Stearns displayed no aggressive or threatening behavior that would justify its immediate seizure. Instead of demonstrating recognized exigency, the record shows that Detective Tangler had ample time and opportunity to obtain a warrant through the Ninth Circuit's established emergency duty judge system. So Boomer said, wonder if it can be considered probable cause. I mean, even with probable cause, though, you would still get a warrant. You know what I mean? She did ask if she could look to see if he was signed into his Google accounts. That's what she asked first. She did. That still doesn't negate a Google Drive search, though. Yeah, it is a privacy issue, and you do need a warrant, technically. So that's why I'm concerned about it. Because he did give permission verbally several times, and I'm hoping that that's enough to hold up in court. Considering it's Florida, I feel like it might be. If we were talking about like maybe Michigan or California or something like that, I'd be a lot more concerned, but I'm still concerned. Brenda said, with thousands of CSAM of Maddie and thousands of other CSAM of other innocent children, there's no way in hell they are going to throw out the phone search. And that's what I mean by like considering that it's Florida. I hope that that's how it goes. Referencing states that have the death penalty as opposed to states that don't is basically my reference in stating, this is Florida, not like Michigan or California. Flora said, so yes, just asking to see if he was on Google in that moment, but later they told him they'd be downloading his phone and if that was okay. And he said, yes. Yep. Legally, if they suspected Stephen Stearns concerning Maddie, they should have obtained a warrant to keep it above board and legal. Yep. Chloe Moon, good to see you. I can't even imagine if Stephen Stearns got the Alfred just because of a stupid search warrant. Yeah, and that's where we're at with it. Like, why didn't we get the warrant? Just to be safe. Under Administrative Order 7-84-11, which has maintained a 24/7 emergency duty judge protocol for nearly 40 years, specifically to handle after-hour warrants. And they're saying there's always a magistrate on call that you can call to get a warrant. So why didn't you do that? The United States Supreme Court has emphasized that the ability of telephonic warrants is relevant to the exigency analysis. They cite Missouri versus McNeely from 2013. Here, Detective Tangler's complete failure to pursue these readily available warrant procedures during the 9.5-hour seizure, during which Mr. Stearns was completely deprived of his ability to communicate with family members or access any of the phone's essential functions, is particularly erroneous and negates any claim of exigent circumstances. Despite the well-established warrant system and the availability of an emergency duty judge at 1:30 a.m., the detectives deliberately chose not to utilize this source, further demonstrating the unconstitutional nature of their actions. 3. Now, why didn't they use that source? Did they think it wasn't enough evidence to get a search warrant on? And if they thought that it wasn't enough evidence for a judge to grant them a search warrant, that's going to be an issue in court. Blue Sapphire said like this, do you mind if we inspect your phone to clear you? Like, right. I mean, I agree. They did find images on the USB, but not of Maddie. Now, we've talked about earlier in the stream, we've discussed if they could say, well, there's these images on the USB drive, and then go look at the phone and say, we need access to the phone. We need to pull up the Google Drive because he has these images on a USB, but I don't know. Oh, look, a squirrel said a child was missing and could have been bleeding out somewhere or starving. If that isn't exigent circumstances, I don't know what is. I agree. Michelle said, I'm giving a big blanket hello to everyone. Hello. Be safe driving. They asked, can I look at your phone? But she did not have permission to search his Google pictures. Right. That's the issue. And his defense could say he was under the influence of drugs. And that's going to be an issue too, because he references being cold, not have eating. He wasn't eating. He was barely clothed or whatever, standing outside in 40-degree temperatures, all of that. Even if he did delete everything, they could get a warrant to subpoena the records from Google. Nothing is ever completely deleted. Right. And I don't know. I just wish they would have got a warrant. We wouldn't be here if they did. 3. All evidence derived from the unlawful seizure must be suppressed. Oh my God, Flora. When consent is obtained after illegal police activity, such as an unauthorized seizure, the unlawful police action presumptively taints and renders involuntary any subsequent consent. They cite Norman versus State and Bailey versus State from 1975. The consent will be held voluntary only if there is clear and convincing proof of an unequivocal break in the chain of illegality sufficient to dissipate the taint of prior official illegal action. The fruit said, fine, let him walk. Wonder how long he'll last in the wild. I'm not saying, but I'm just saying. Right. I get it. And I hope that the judge is like, right, but like, he gave oral consent in all of these audio interviews that we have, or that the prosecution has. And if they hadn't searched that, they wouldn't have found all of the images that are necessary for the whole entire CSAM trial, which is going to in turn put the death penalty on the table in the homicide case if we get to that, if he's convicted of the CSAM stuff. So I'm hoping that that's going to be the thing. Like, this evidence is too important to just say that, it was obtained illegally, especially when you have him saying on audio several times, yes, you can look at my phone. Of the poisonous tree doctrine requires suppression of both primary evidence obtained from the initial illegality and secondary evidence derived from the exploitation of that illegality. They cite Wong Sun versus United States from 1963. The relevant inquiry is whether the evidence was obtained by exploitation of the initial illegality or by, quote, means sufficiently distinguishable to be purged from the primary taint, unquote. The Florida Supreme Court has consistently held that evidence discovered by exploiting previous illegal conduct is inadmissible. They cite Craig versus State from 1987. Here, there was no break in the chain of illegality between the unconstitutional seizure and the subsequent searches of the phone. The extended deprivation of Mr. Stern's phone created coercive circumstances that led to the midnight, quote, consent, unquote, for its forensic examination. Any purported consent was inexplicably intertwined with and the direct product of the illegal seizure. The Google warrant and all derivative evidence were direct products of the initial unlawful seizure. So they're saying basically you got this evidence illegally, right? So all the images, everything you have from the Google Drive now needs to be thrown out. And any evidence that you obtained, any information in this case that you obtained that came from the Google Drive. So like I was saying earlier, if let's say, I don't know, they found out where Madeline's body was because he took a picture of her body on the phone and in its resting place, and they used that to find her body. If this was thrown out, then they would have to say they found her body a different way. Now, I'm just using that as an example. Obviously, we have the flat tire witnesses. I don't think he had a picture of her deceased on his phone. I'm just using it as an example to explain to you like what they're saying. All the images would have to be thrown out, and anything that led them further in the investigation that was due to the images, they're saying they want thrown out. Remember during the interview right before his arrest, he says something about taking some type of medication. Yeah, they reference that in this one. He talks about taking trazodone or something to that effect. I'm not sure. It might not have been that one, but something to that effect. Lil Red, do you know that he's blaming Jen specifically? I would love to know where you heard that. Veronica said he was on a ton of meds, but it was an excuse. Plus, he was like that every day through TIO, in my opinion. Yep. Aw, Abellis, that's so sweet. As law enforcement would not have had access to the phone's data without first illegally seizing and retaining it. Therefore, all evidence obtained through exploitation of this unlawful seizure, including the phone's contents, the Google warrant results, and any investigative leads developed therefrom, must be suppressed as fruit of the poisonous tree. Conclusion. Detective Tangler's warrantless seizure of Mr. Stern's cell phone represents precisely the type of unreasonable government intrusion that the Fourth Amendment was designed to prevent. The 9.5-hour deprivation of an essential communication device without consent or exigent circumstances violated fundamental constitutional principles. All evidence obtained through exploitation of this unlawful seizure must be suppressed to uphold the integrity of the Fourth Amendment and deter future violations. So basically they're saying it's his Fourth Amendment right, and I think, yeah, right here, Lil Red said, Fourth Amendment to the U.S. Constitution and the Electronic Communications Privacy Act, or ECPA, restricts government access to user information without proper authorization. So they're saying they violated that right of his. And like Lori said, it's like, if you think about it, it's like if someone asked you to let them use your phone and you agree, but then they go through your call log, they look at your bank statements, they check out all your apps and are messing around in your YouTube and your Facebook. Basically, that's what it is. Wherefore, the defendant respectfully requests this honorable court, 1, to set this matter for an evidentiary hearing pursuant to Florida R Criminal Code P 13.90 subsection H subsection 3. Number 2, suppress all evidence obtained from and derived through the unlawful seizure of his cell phone. And 3, grant such other relief as this court deems just and proper. And it was signed by Melissa Vickers, public defender. Okay, so that is the first one. That's interesting that it shows like a page turning, because I don't do it that way. Excuse me. So that's the document that the judge is going to rule on or listen to. That document, the unlawful search, the unlawful seizure, and the other one is what he's going to listen to and hear about on April, I think it's 23rd. We just talked about it in chat at 2 p.m. That's what he's going to listen to. Now we're going to listen to this discovery document, which is, again, me reading a document, but it's basically all the evidence they have against him that they're going to use in court. This is discovery. And several other photographs of Maddie. This is discovery. This is what they're saying. We know that Stephen did the CSAM and the homicide because of these reasons. I'm going to talk about them. All right, so this is a 57-page document. It was in the recent file drop. It starts off as the state attorney. It says that so this is the one from March that was just recently updated. And if you guys don't mind, please hit the like button. I appreciate that, Miss Sarah. Miss Sarah said, don't forget to hit the like button. It supports the stream, boosts visibility, helps grow our community, and lets us know you're enjoying this. Yes, thank you so much for that, Sarah. I appreciate that. Real quick. Orange Rose said he's time blind, has ADHD, on meds, cold, hungry, tired. Can we just give the poor guy a pass? Right? A pass? Bullshit. Oh. No, I don't have it readily available. Can we just give him a pass? Nope.
Yes. A bullshit? A bullshit? A bullshit. A bullshit.
Yeah. I hope that they deny that motion. I really do. Lorette said when he talked about the autopsy report, he acted like he was surprised that she had broken bones in the neck. And that's why I'm telling you, I think it's possible that it happened with the leash. He was on Telegram at 11 o'clock when they were sent upstairs to go to bed. So I don't know. Yeah, I'm trying that too. So you let me know if you get anything, and I'll let you know if I get anything. You got my email, so if you ever need anything I have, let me know. And I got yours. Lastly, before we get started, Sluicy Eslo says, I'm late. I can't remember what it's called, but I think they're allowed to hold on to something when they suspect a crime, like how they can lock down a house while awaiting a search warrant. You're right, but they didn't ever get a search warrant. And what reason would they have? Well, you could say that, his suspicious statements justified them thinking that there was a crime. So yeah, we'll see. Like you said, we'll see. No passes. He needs to pay. I'm with you. Did the text Jen sent him that night was by SMS? I think so. I don't know. Hey, Rubber. Every police department interviewer and processing center should just keep a picture of Carmen Miranda throughout. Yeah. I'm assuming that's the person that the Miranda rights were named after. It's from March 4th, 2025. Okay, the defendant is Stephen Michael Stearns, and it gives us the case number. This first page reads, if the requested records contain any of the following confidential or exempt information, it has been redacted or withheld pursuant to applicable law. And it tells us that active criminal investigation, intelligence information, and or substance of confessions, attorney work product, bank account, debit and credit card numbers, Department of Motor Vehicle information, identifying information of victims of sexual offenses and or child abuse, items sealed by order of the court, and some law enforcement reports were released in discovery with sections redacted by the Unit for Homicide Investigative Information. Page 2 is going to give us, so it did say other, and it was talking about that document that I have where the DA accuses Sheriff Mark Lopez of releasing a picture of the homicide or the death occurring and not stating that it was a picture of her deceased laying on the ground after she had been found, which I find really curious. I don't know anybody who's specifically seen the photo of Madeline that Sheriff Marco Lopez accidentally leaked. I do know per the property records thing, they talk about Sheriff Marco Lopez coming out and taking photographs of the scene. But I heard it was a picture of Madeline laying on the ground out there in the property after she was already deceased that accidentally got leaked by him on Instagram. And he paid a fine for all of that. But then you have these court documents, I think 2 different ones, 3 different times, stating that it was a photo of the homicide or the crime being committed. So I'm always questioning that. Now, and I will tell you in this one, there is a law, I do believe it's called Marcy's Law, where they redact victims' names of crimes. So there actually was more redacted in this and less redacted. We got more information we didn't have before, but names are redacted that weren't redacted in the original. But I'm pretty good about being able to tell whose name's supposed to be in the redacted part, so I kind of just fill in for it. Mr. Stern's arrest warrant. I'm actually going to make this smaller so you can see the whole thing. You have the picture, so it's not a picture of something happening then, right? It's just a picture of her after she was deceased, Lil Red. I would love to know that from you because I found it weird that they referenced the crime being committed. No, I mean, if you want to, that would be fine. I'm not going to put it on YouTube, but I'm just trying to figure out, it's just showing her deceased, right? It's not showing like a crime being committed, correct? Because it's weird to me how they reference it as a crime being committed in the documents. We talked about it on other lives. So there is Mr. Stern's arrest warrant in all of his glory. It tells us that this is an arrest warrant, Circuit Court of the 9th Judicial Circuit in and for Osceola County, Florida. And it is the state of Florida versus Stephen Michael Stearns, who is the defendant. It is the Kissimmee Police Department. Gives us the court case number. He was born April 25th of 1986. He is a white male. His height is 6'2". He's 220 pounds. He has black hair and brown eyes. He has brown eyes because he's full of poop. Says to all and singular sheriffs of the state of Florida, special agents of the Florida Department of Law Enforcement, any investigator of the several states' attorney's office, and or any police officer of the Kissimmee Police Department, an affidavit or sworn complaint having this day been presented to me, the Honorable Judge Whitehead, in and for Osceola County, Florida, 9th Judicial Circuit, wherein it has been alleged that on or between error, reference source not found, and present in Osceola County, Florida, the defendant Stephen Michael Stearns did, in violation of Florida statutes, and commit the following offenses of sexual battery, victim under 12 years old from the familial or custodial authority. Therefore, you are hereby commanded to arrest instanter to said defendant if he or she be found within your jurisdiction and bring him or her before the proper court to be dealt with according to law. The said defendant. Okay, but y'all are telling me there's no crime being committed in the photo. Sorry, I had to talk to Mr. Speculating. He's at work and he had texted me. So y'all are telling me that it's not of a crime being committed, which is good. Yes, I can describe what Telegram is. Let's do it this way because, I mean, I'm kind of new on it myself. So Telegram, what is it? Telegram is a cloud-based free messaging and calling app that emphasizes privacy and security, allowing users to send messages, photos, videos, and files, and create groups and channels with features like end-to-end encryption and self-destructing messages. So Telegram is primarily a messaging app, but it also supports voice and video calls. It's a cloud-based service, meaning you can access your chats and files from multiple devices. Telegram prioritizes user privacy and security, offering features like end-to-end encryption for secret chats, self-destructing messages, and the ability to control who can see your phone number. Groups and channels. You can create groups for up to 20,000 people or channels for broadcasting to unlimited contacts or audiences. Bots. Telegram supports bots, small applications that run within the app, and provides tools for developers and create their own. Telegram is free to use, offering a wide range of features without requiring users to pay. Telegram also supports file sharing, and users can access their chats and files from the web portal or Chrome extensions. Strategic Eyes had a video on Telegram that I'm going to see if I can use, which I'm sure he wouldn't mind, at some point in the next couple of days. We are going to deep dive the Telegram aspect of this case in the next couple of days. I was texting him on the phone, but I will tell him you said hi, my lovely Abelis. Yeah, I understand why everybody was upset, but considering that it is a picture of the crime scene and the paperwork where they go out to the crime scene says that he went out there and took a photo, I mean, I can understand. It should have been taken on a different phone that he wasn't using just for everyday use, but, you know, it shall be admitted to bail in the total sum of $0. It was ordered the 29th day of February by Judge Whitehead. So that's his warrant. This is the state of Florida versus Stephen Michael Stearns. Gives us his information. It says affidavit for arrest warrant. It reads the state of Florida, county of Osceola. Digitally appears the affiant, Detective Brian Moore, a sworn law enforcement officer, to wit, an officer for the Kissimmee Police Department, who makes this affidavit and states under oath that affiant has probable cause to believe that certain laws have been violated in Osceola County, Florida, and that on or between February 22nd of 2022 and February 26th of 2024, the defendant, Stephen Michael Stearns, did violate Florida statutes and commit the offenses of sexual battery, victim under 12 years old, for familial or custodial authority. Your affiant, Detective Brian Moore, is a sworn law enforcement officer employed by the Kissimmee Police Department and has been employed by said agency since April 9, 2018. Your affiant currently investigates crimes in the... Okay, so I see numbers are dropping like flies. So if do y'all want to, here, let's go do this. I don't know. Let me know if you still want to listen to Discovery and we'll come back to it. I'm going to borrow Strategic Eyes Telegram video and we'll talk about that. Let me grab the link to his channel so we can discuss that, because I've got a couple of things I want to discuss about that, and I'm going to pin him to the top of the chat box. Here we go. Hold on a minute. Yeah, it's from 5 days ago, so I'm sure he won't mind. Wanted to make sure he didn't just like put it out. I need to access this live. Okay, so let me drop the link and we're going to listen to Strategic Eyes talk about the Telegram thing. Oh my goodness. It's right there. Right there. Let me know if y'all want to go back to the Discovery, but I saw the numbers were dropping like flies. So I guess y'all do not want to watch Discovery. So this is our friend Strategic Eyes. He is very, very nice. Very, very nice person. I think it is a video because it's not very long, but he kind of breaks down the Telegram stuff or brings to the forefront some issues about the Telegram stuff. If you have not subscribed to him and checked him out, please do so because he has lots of really interesting information. Oh, he's been uploading like crazy. All right. This is the one we want. This is from 5 days ago. Again, this is our friend Strategic Eyes. He is pinned to the top of the chat box, and I will put him in the description box.
Strategic back again.
If you have not subscribed to him, please do so. Hold on just a minute. One more thing, actually.
I got an interesting show for you guys today, and I just decided to jump right into this, all right? I want to jump right into this and get to the meat of it, because Aki pointed something very interesting out to me. And what she pointed out is a nexus between what Stephen Stearns...
Okay, hold on a minute. Let me put it on regular speed because I had him sped up. I don't know why my computer is wanting to act crazy today. Oh my goodness. Computer. Hold on just a minute. Good Lord. All right. Let's try this again.
father said during a conversation that he had with his son, and what Gray Hughes Investigates discovered during his own investigation of the Madeline Soto case. Now, what I want to do is I want to start off by playing for you the conversation that Chris Stearns had with Stephen Stearns. Let's listen to that right now.
You were awake when sent her into the room with you?
Yeah.
And she was fine when she came into your room? What time at night was that?
Maybe 11-ish or so, I'm not sure.
What time did she go into the room? She was fine when she went in the room with you. Yeah. Around what time did she go into the room? Says Chris Stearns. Stephen Stearns answers around 11. Now keep 11 in your head.
Okay, now he's going to tell you to keep that they went to bed at 11 o'clock in your head. Strategic Eyes is a detective. I think he's up north somewhere. I don't know where, which that's not important anyway. But he is a detective and he looks at these cases all the time. And he's really great. So keep that in mind. And we're going to talk about it. Yeah, I had some questions because it was 11:30, but dang, hold on. I'll pull the steps because I think it's at 10:30 or 10:40 that she takes the steps upstairs. I will try to grab that document. I do believe I still have it on my phone, and we'll correlate the times real quick. So for now, let's listen to Strategic while I try to get these documents pulled up.
Yeah, but I'm gonna play for a few seconds just so we can get some context for the conversation. I don't like cutting people off because people say, well, what's the context? Well, let's listen to the context. But what you need to remember is 11 p.m. That's the time that Stephen Stearns just told his father that Madeline went into the bedroom with him. Let's keep going just for a little context.
Okay, so she was fine. So what happened between 11 and whenever you found her?
Well, that's the $1 million question, isn't it?
That's the $1 million question, isn't it, Dad? I just added that. He didn't say that, but he said that's the $1 million question.
Yeah. I mean, when you say you were out of the room, for what length of time were you out of the room?
I don't know.
15 minutes?
No. I left the room a couple times. The first time I left to go to the bathroom.
All right, so he starts mealy-mouthing on when he left the room. We all know these are lies. Lies. We all know he's telling stories. We all know you can't believe nothing Stephen Stearns says.
Oh, hell no.
Oh, hell no.
But.
Oh, hell no.
But what his time.
All right, I'm pulling up the document that shows the steps taken so we can see what time she went up. Good Lord. Like, it did not want to come up. All right, so we're going to look at the steps taken. So, it says at 14:30, hold on. At 23:19, 31 steps taken and 1 floor climbed, which matched the time when Jennifer sent Madeline and Stephen upstairs to go to bed. So what is 23:19 in military time? Let's see. 23:19 military time. It's 11:19. So it was 11:19 when she went upstairs to go to bed. All right. So, let me pull this back up. So it's actually 11:19 when she goes upstairs and goes to bed.
Times are corroborates with Jen Soto's time. I think everybody pretty much can agree that it's highly likely that Madeline did go to the room at 11 p.m. We don't know for sure. There's a lot we don't know for sure. We're just speculating, but we know that Maddie was in that room. But something else happened at 11 p.m. that we got to give a big shout out to Gray Hughes Investigates for discovering during his investigation. See, Gray Hughes was able to get this information from all the FOIA requests and all that stuff. He was able to determine that Stephen Stearns was logged into the app at 11 p.m. Let's listen.
Called Telegram. This is really significant, this piece of information that we got from Gray Hughes Investigates.
If you have not checked him out, please check him out, and I will look at that. We're gonna listen and see what it says.
Now, it's from an app called Telegram. What is the Telegram app? It's a messaging app focused on speed and security. Over 700 million monthly active users. You can send messages, photos, videos, and files of any type. You can create groups of up to 200,000 people. You can create channels for broadcasting to unlimited audience.
Are you guys listening to this while Vinny narrates it for us? You guys see what you can do with Telegram? I know you guys who are watching this, you've already heard of the allegations of what Stephen Stearns may have been doing on Telegram, but we're corroborating that he may have done those things that people have been speculating. Let's keep going. Listen to Vinny read out all the horrible things you can do with Telegram. They're not horrible if you use them in a positive way, but we know how Stephen Stearns was used, or at least we suspect how Stephen Stearns may have been using this application. But let's keep going. Go ahead, Vinny, talk to us.
Audiences, you can contact people through phone number or username, and it uses end-to-end encryption, ensuring they have no data to disclose.
So I want to look at the time because we just saw it was technically through the report, it was 11:19. I'm going to double check and see if there's a possibility that she was upstairs before then, because I don't think it's out of the realm of possibility to think that she might have been up there before then, but I'm definitely going to double check right now. If he was on at 11 o'clock and she wasn't up there, then he could have been doing a number of things that didn't involve her, but I would think that it did personally. But let's continue to listen.
You get that? So your data doesn't go to the app. So when the search warrant comes for the app, they have
nothing on the app. And when they send a subpoena to Telegram, Telegram says, we delete it. We have nothing on our servers. Nothing to see here. Means you get no evidence from Telegram. Let's keep going.
nothing to give to authorities because of this encryption. And they say to this day, we have disclosed 0 bytes of user data to third parties, including governments.
Right.
Okay? So it's pretty secure, this Telegram.
Right. So why are we putting this together? What Aki brought to my attention. Stephen Stearns, Jen Soto, Chris Stearns, all of these people are made aware by Stephen Stearns that Maddie goes to bedroom number 4 at 11 p.m. 2300 if you're in the military or law enforcement. Stephen Stearns logs into the app at 11 p.m. Law enforcement have evidence of Stephen Stearns abusing Maddie throughout the night. Could it be that this theory that I didn't even buy in completely, I'm not one of the people who are pushing this theory. Look at my
So you get the idea. I'm not going to play his whole video because I want you guys, I mean, definitely go check him out. You get the idea that Stepan was in Telegram at 11 p.m. and Maddie was up there with him. Now, the steps taken thing that I just pulled up shows that she took 9 steps at 10:09 p.m. and then at 11:19 p.m. there is however many steps in one floor climbed. Now, if he's running some kind of operation or doing some things, I'm sure he's going to be on there. Like, okay, I'm not, let me put a trigger warning up because this is going to be hard to talk about. But if he's got some kind of thing, this is me speculating, by the way, just speculation. If he is used to doing this, he's got a group of people that watch what he does. Then he could be, you know, signing into the app saying, hey, I'm going to be live in a few minutes. Basically, you know, getting the people ready for the show. Heaven forbid. I mean, I think that's a possibility just because he got on at 11 and she came up at 11:19. I don't think necessarily means that it's not connected. I think it could very much so be connected. Dainty Dane, it was Madeline. Hey, y'all. So I've got these discovery documents. It was Madeline that took the steps. So we're going to look at some of these other documents I have that are pretty interesting. We'll look at what they have on the traumatic brain injury. This is all that can be found on Stepan's traumatic brain injury. And this is important because it's going to be used in court against him. I mean, not against him. I'm sorry. This is his only happy Valentine's Day. So today I want to talk to you real quick about the CSAM stuff. He's going to try to say that he had a traumatic brain injury that made him do the things that he did. This is all that can be found about the traumatic brain injury. Abella said, bad girl. He called it exactly 11:50 on the dot. Aw, I'm glad. I believe he was filming that night too. And I believe that even if Madeline wasn't up there quite at 11 o'clock, that he could have been setting things up, unfortunately. All right, so let's see what this is all that can be found by the public anyway about Stepan Stern's supposed traumatic brain injury. This is what the defense is going to try to use to say that, you know, oh, my client did these things because he has a traumatic brain injury. That's why he abused this child. This is all that can be found. Maybe if it'll load. About what I was able to pull on Stepan's traumatic brain injury. There are some parts of this document I feel are important. I want to thank Plunder because she shared a video on this, on what she was able to pull. And because of that video, I was able to pull this. So I do want to take a second and thank her for that. If you have not checked out Plunder, I will drop her link so you guys can go check her out as well. Thank you so much, Plunder. So I want to start all the way at the very end. I need to show you something here first, and then we'll go back to the beginning. So if you notice right here where it says pages, all of them are 0. And over here where it says time underneath each one, they're all 12 a.m. Okay, so I'm not going to continue to read that. But what I want to show you, what I want to start out with is that July 8, 2022, it reads retention met, eligible for destruction. So July 8th, 2022, basically all these documents were destroyed. And this is all we have left. Now, this is basically just going to go through what happened as far as the court case. So let's start all the way at the beginning, and I will read it to you, and we will talk about it. So on April 1st, 1998, April Fool's Day, they made a civil cover sheet. We're starting right here. On April 1st, 1998, there was a complaint entered with an attachment. On April 1st. So on April 1st, 1998, when they filed a complaint, Stepan would have been, what, he's born in 86. 90, I mean, he would have been like 12 years old when this happened. He would have been very young. That's hard for me because it's like you're supposed to show that, okay, because of this traumatic brain injury, this person was changed. from the person they used to become. But if he was from the person they used to be, but if he was only 12 years old, how do you know who he was before, and that the brain injury changed him? But again, I mean, he didn't even stay overnight at the hospital, so I don't think it was anything but maybe a concussion. Right, CJ, exactly. I think that's very possible, Flora W. 1998, a summons was issued for all parties involved. On April 6, 1998, there was a notice of service process. Bill Nelson from Geico General Insurance Company. On April 13th, summons served. On April 6th, 1998, to Timothy C. Sumner. So that means basically on the 6th, he was served, and they entered it into the court system on April 13th of 1998. On April 24th, 1998, there was a notice of service of interrogatories. On April 24th, 1998, there was another notice of service of interrogatories. On April 24th, 1998, there was a defendant's request for production from Geico General Insurance Company. So basically what this is the court case where they're suing the people that hit Stephen Stearns. And they're going through court, and you know, all of these things are happening, like the motion, Stephen's lawyers filing, all that's going on with this. On April 24th, 1998, there was a defendant, Geico General Insurance Company's answer and defense. So Right, basically Cynthia? they answered to the complaint. On April 24th, 1998, there was a request to produce, probably evidence. April 24th, 1998, defendant Timothy C. Sumner's answer and defenses to plaintiff's complaint. April 24th, 1998, there was a letter dated April 22nd, 1998, to Donna D. Woods to the clerk. On April 28th, 1998, there was a notice of service of additional interrogatory. We need to go to the next page. May 8th, 1998, there was a second request to produce. May 8th, 1998, there was a notice of taking depositions from the Sarasota County Fire Department. So that tells us the fire department arrived on scene, and they basically want to get them ready for court as far as their witness statement and things like that. So the fire department came to the scene. Cynthia said, I like his lawyers are leaving no room for appeals. I'll be happy when he joins Wilson at Union Correctional. Yep, me too. Flora said, Jen knew she would definitely lose Stephen to prison. And seriously, I think it was Jen seen being dropped off at the school pretending to be Maddie. I wonder about that quite a bit, as much as she references checking cameras and trying to make sure people are seen at these places and that places, honestly. That from that day. May 8th, 1998, there is a notice of production from non-party, Sarasota Memorial Hospital, Pediatric Neurology Associates, Physician's Assistant, Edward R. Dietz, J.R. D.C. Kenneth A. Gordon, Medical Doctor, and Radiology Associates of Sarasota. Now, that's what's most important. So basically, that's telling us that Stephen went to Sarasota Memorial Hospital. He saw a Pediatric Neurology Physician's Assistant by the name of Dietz or Dietz. He saw Medical Doctor Kenneth Gordon, and there was radiology. So he had some kind of radiology test done on him. He also had a neurology test done. They checked him for any kind of issues with his neurological, which is his head. And then there was some radiology tests done as well. And they're pulling those people into court to testify as to what they did, what they saw, his medical records, what happened. So that tells us that he did have some kind of injury to his head, specifically the neurology aspect of this notice of production. Will that be enough for court? So, I mean, basically, I can't, explain it in any other way than I just did. He was seen by doctors and checked by neurology. So will that be enough for court? I would think not, since he wasn't even held overnight. Oh, wow. So he really did that. Confirms to me that he finally made plans for that night. The sickest plans, I highly suspect. Yeah. Yes, MB, I agree. And if he was filming, an essay was going on, and if they called 911, they definitely know she had been essay, so they had no choice but to cover that up. Yep. That's what I speculate, Flora. Abraham says, we are overthinking this Jen stuff too much. Jen is textbook definition of an idiot, someone stupid. She was a horrible mother, but she wasn't involved. That was all Stephen. I don't know. I don't think she was involved, but she knows a lot of things that she shouldn't know if she didn't know about the cover up. And I can't get over the Woody Allen comment in the Electra complex. That be enough to prove that he had a traumatic brain injury. This so far lets us know that he was in the hospital, he was seen, and they did some tests. So that's really interesting. Continuing on with the document, May 14th, 1998, summons served on April 20th of 1998 to Jason Earl Cobb. May 28th, 1998, defendant Jason Earl Cobb's answer and affirmative defenses to plaintiff's complaint. May 29th, 1998, subpoena DT without depth served on May 27th, 1998, Sarasota County Fire Department. On June 1st, subpoena DT without deposition served from May 28th, 1998, Sarasota Memorial Hospital. June 1st, 1998, subpoena DT without deposition served on May 28th, 1998, Radiology Associates of Sarasota. On June 3rd, 1998. I didn't know that, Cynthia. Jen is tumbling down the Nile River. That's funny. Yeah. I mean, I agree with that, Blue Sapphire. And they're going to talk about depositions being taken. Mac Daddy is out, as you can hear. The 8 subpoena DT without deposition served from June 1st, 1998. Kenneth A. Gordon, medical doctor. June 8th, 1998 was the plaintiff's request for production to Jason Earl Cobb. June 8th, 1998 was a notice of service of interrogatories to Jason Earl Cobb. June 8th, 1998 was the plaintiff's request for production to Timothy C. Sumner. June 8th, 1998 was a notice of service of interrogatories to Timothy C. Sumner. June 8th, 1998 was a notice of taking depositions, Jason Earl Cobb. June 8th, 1998, there was a subpoena DT without deposition served from June 4th, 1998, Edward R. Dietz Jr., DC. That's going to be the physician's assistant from the hospital. June 8th, 1998, notice to set for jury trial. So they're calling all these people in to give depositions and basically prepared them to be questioned on the stand, and they are having a jury trial. Now, again, this is to sue the people who basically ran Stephen over, but it's all that's left because, as in the beginning of this document I read to you, that all the files were destroyed. And at the end of this, we're going to see how the case progressed through court. Of taking deposition, Timothy C. Sumner. June 12th, 1998, order for case management conference on August 19th, 1998 at 3:30 p.m. Bennett. June 18th, 1998, subpoena DT without deposition served from June 4th, 1998, Pediatric Neurology Associates, PA, physician's assistant. June 22nd, 1998, notice of taking deposition, Jacqueline H. Barclay, medical doctor. June 23rd, 1998, notice of production from non-party Geico Insurance Company. June 23rd, 1998, amended notice of taking depositions, Jacqueline H. Barclay, medical doctor. So that's another doctor that he saw. June 24th, notice of taking deposition, Stephen M. Stearns, Deborah Stearns, and Christopher Stearns. July 2nd, 1998, notice of service of answered interrogatories, Timothy C. Sumner. July 7th, 1998, defendant's motion to compel, Timothy C. Sumner and Jason Earl Cobb. June 7th, 1998, notice of hearing, June 24th, 1998, no time listed. July 8th, 1998, notice of service of answered interrogatories. July 2nd, 1998, notice of answered interrogatories, Timothy C. Sumner. July 7th, 1998, defendant's motion to compel, Timothy C. Sumner and Jason Earl Cobb. July 7th, 1998, notice of hearing. July 24th, 1998, no time listed. July 8th, 1998, notice of service of answered interrogatories. July 9th, 1998, defendant Timothy C. Sumner's response to plaintiff's request to produce. July 9th, 1998, defendant Jason Cobb's response to plaintiff's request to produce. July 13th, 1998, notice of service of demand for judgment. July 13th, 1998, demand for judgment pursuant to Rule 1.442. So now they're demanding judgment. And at the end of this, what Deb references herself as is absolutely astonishing. Southern Cat said, Jen knew all of it. Apparently, there's big money in that sicko stuff. I still believe Jen was a part of the unaliving. They all had way too much money for no one to be working. Yeah, it's a possible speculation. I mean, I don't think it's out of the realm of possibility at all. Has anyone worked with an employee who was good at their good, but only when it's done according to policy and procedure. The moment a different scenario comes up, they can't manage. Jen is that person. I mean, I get it. I get what you're saying, and I respect your opinion, but I don't know. I don't know if I'm quite there yet. Of civil procedure. July 24th, 1998. Notice of cancellation of hearing. July 24th, 1998, UMC. July 27th, 1998. Subpoena DT without deposition served. July 21st, 1998. Claims Department, Geico Insurance Company. July 28th, 1998. Plaintiff's response to defense Timothy C. Sumner's request to produce. July 28th, 1998. Notice of serving answers to interrogatories. July 29th, 1998. Defense Timothy C. Sumner and Jason Earl Cobb's supplemental response to plaintiff's request to produce. August 14th, 1998. Notice of serving answer to additional interrogatory. August 26, 1998. Stipulation for substitution of counsel. And there is 4 stipulations for substitution of counsel, all on August 26th of 1998. And then on August 26th of 1998, there is an order granting substitution of counsel. August 28, 1998, order setting case for jury trial and optional pretrial conference on December 7th, 1998. And it says Bennett. I'm going to assume that's a courthouse. September 11th, 1998, request for copies to the defense. September 17th, 1998, third request to produce. September 28th, 1998, request. So they're having to put in a lot of requests to produce for copies. October 9th, 1998. Defense Timothy C. Sumner's witness and exhibit list. October 9th, 1998, notice of compliance with request for copies. October 14th, 1998 is defendant's witness list and exhibit list. October 14th, 1998 is first supplemental interrogatory. The witnesses and the, oh my goodness, the evidence. 16th, 1998 is a motion for continuance by Jason Earl Cobb. October 16th, 1998 is a notice of hearing on October 30th, 1998 at 9 a.m. October 16th, 1998, defendant Timothy C. Sumner's supplemental list and exhibit list. October 16th, 1998, there was another request for copies. October 19th, 1998, notice of taking deposition DT, records custodian Joseph Ferrari, medical doctor, Kenneth A. Gordon, medical doctor. So they're calling in the medical doctors. They have a court case. 3 medical doctors he was seen by for this traumatic brain injury. So maybe it is something. October 20th, 1998, notice of taking depositions, Sherry L. Sumner. October 21st, 1998, defendant Timothy C. Sumner's second supplemental witness and exhibit list. October 22nd, 1998 is the defendant's amended witness list. October 22nd, 1998 is a notice of taking depositions, Matria Mazarhari, PhD, which I'm going to assume is some kind of doctor. October 22nd, 1998, subpoena for depositions served on October 21st, 1998 to Sherry L. Sumner. October 23rd, 1998 was notice of taking depositions, Jody Wright, Steve Herring, Kelly Auchenpugh, and Valerie Wallace. October 23rd, 1998 was the plaintiff's witness and exhibit list. October 26th, 1998 was the amended notice of taking depositions, Atria Mazari, PhD. October 28th, 1998 was a notice of change of address, Randy L. Stowell. October 28th, 1998 is a subpoena DT for depositions served. October 19th, 1998, medical records custodian Kenneth A. Gordon, medical doctor. October 28th, 1998 was a request for plaintiffs to submit to examinations and request to produce at examinations. October 28th, 1998 was a motion to shorten time for IMES motion to. So these are all the motions and things they're entering in court. We're going to slide to the end real quick. And I'm going to talk to you guys about one more document that I find just appalling today. As to Geico General Insurance Company. And then July 8th of 2000. Go back a little bit. I want y'all to see how this a record order of dismissal with prejudice of action. February 19th, 1999 was a record order of dismissal with prejudice of action. February 19th. So the court case was dismissed with prejudice. 1998 was a stipulation to dismissal with prejudice. February 19th, 1999 was a final disposition form. May 12th, 1999 was a joint stipulation of dismissal. May 12th, 1999, was a record order of dismissal as to Geico General Insurance Company. And then July 8th of 2022 was retention met, eligible for destruction, which basically
the one that has this might
means
not
they
be
held
him.
the records for the extended period of time, and so they had them destroyed. That's why, again, all the pages over here, party name, Stearns, Stephen M., minor by N, and they are the plaintiff. Stearns, Deborah, his natural mother, that was a plaintiff. Cobb, Jason Earl, was a defendant.
No, that's not the one where she references herself as mother and best friend. There is one though that we've talked about in the past where she does, and that tells you about their relationship. You know what I mean? Like, as it's always weird, and it's always
Violate
been
Florida
weird.
statutes and commit the offenses of
I don't get it. Like, I don't know. Their relationship is highly toxic, in my opinion. So have you guys heard about the motion? Hold on. I don't even know if I have it here. Nope. Have you guys heard that they are basically saying that you cannot have any sympathy for the victim? We're just going to listen to a little bit of it, but basically this is a document stating that in court, they're not allowed to have any sympathy at all for Maddie. And they can't vilify Mr. Stearns and the reasons why. Like, these motions that they entered are crazy. There's another one that is requesting that the jurors tour the execution chamber and watch this horrific documentary. It's insane, these motions. For arguments designed to create sympathy for the deceased or vilify Mr. Stearns. So you can probably understand why I had a big issue with this document. I got this document from As the Gavel Drops Discord. I will link them. It reads, comes now the defendant, Stephen Stearns, through his undersigned counsel, and respectfully moves this honorable court to prohibit evidence or argument during both the guilt and penalty phase that is designed/presented with the intent of or would have the effect of creating sympathy for the deceased or vilifying Mr. Stearns. Such evidence and argument are contemplated to include, but not limited to, that which details the impact of the offense on the friends and or family of the deceased, the impact of the offense on the community, the life histories of the deceased, or any personal characteristics of the deceased or of Mr. Stearns. In support of this motion, the defendant provides the following. 1. Mr. Stearns was charged by indictment filed on April 24th. So they're saying that you can't have any sympathy for Maddie. You can't talk about the effect it's had on her family, her friends, and the community. And you also can't vilify Mr. Stearns. Like, are you kidding me right now? This document is from As the Gavel Drops Discord. They have this document and many more. And if you want to check them out, I pinned their link. Cindy said, I'm not so about traumatic brain injury. If someone presents to ER with the type of accent, it is reasonable to seem that doctor, CAT scan, MRI, x-rays, and then consultation with ortho or neuro. Yeah, you could go in there and say you hurt your head and all of those things would happen. I get it, and I hope they present that at court. Flora says, so the defense is trying to say feel sympathy for Stearns because he has a TBI, but not for the victim. Exactly. This document's appalling, and it's not even the worst one. 2024 with first-degree murder. 2, the state filed notice of intent to seek the death penalty on June 7th, 2024. 3, Florida law has consistently held that evidence designed to create sympathy for the deceased is inadmissible in the guilt or innocence phase. The Florida Supreme Court reaffirmed this line of cases in Jones versus State from 1990, Lewis versus State from 1979, Roe versus State from 1985, Ashmore versus State from 1968, Hathaway versus State from 1958. Florida law has consistently prohibited such evidence in the guilt-innocent phase of any trial, capital or other. So they're saying in the guilt or innocent phase, but there's other documents that state that they don't want, I'm sure y'all don't want to listen to all of it. These documents are available on my page. There's other documents stating that
basically family can't read victim impact statements at his sentencing, that it needs to be read by a third party or not at all, but they want the jurors and the courts to know about the impact that Stephen Stern's death will have on the family, and they want his family to be able to read that. You can't use the words mercy, compassion, or sympathy with the jurors when doing your opening or closing arguments. They wanted the jury to tour the execution chambers. Now let's think about that. If you have somebody that's selected for jury service, that's never ever seen the inside of a jail or anything to that effect, doesn't know anything about it, and you take them and pull them right into an execution chamber where there's a gurney with straps and all of the things that already look scary, and a gallery where people can sit, and you show them that and say that this is where Mr. Stearns will be, and they also want to show them death row where he will be housed. And I want you to take into account like the other end of the spectrum, like people who have never even seen the inside of a jail cell. What kind of effect do you think that's going to have on them? I'm so sorry, sweetheart. I was reading your thing. Cynthia, I'm sorry, love. Or I'm glad everything was okay. And then you can't even say to have sympathy for her. You can't talk about the effect that her death has had on the community. You want to throw out the phone evidence. You want them to tour the execution chamber, tour death row. Like, all of this shit is insane. He is a piece of damn crap. And he gets to play the victim in every aspect of his life. He's still the victim with his family. His family still treats him as though he's done nothing wrong. He's getting to play the victim in court with all of these motions that are being entered on his behalf. It's absolutely insane. Bad Girl said, this mother trucker thinks he's special because that's not how trial and court works. You ought to see, and I've got a lot of them out, like the most salacious ones I've put out on my channel where I'm reading through them. Like if you're cleaning or something, you should definitely go look through them because it's insane, these motions and things. And that was kind of the topic for today, these motions and the discovery and all of that. I feel like I wasn't real put together today. I had been so busy the past couple of days, but tomorrow I'll have myself a little bit better together. I hope he's got another thing coming, Genevieve. Most people have seen it in films. I hope they will see through them. Oh, you ought to see this film. Hold on. Let me pull this up. Let me pull up this film. If I can remember the name of it. We went over a little bit of it, and I can only play like the first couple of seconds. Hold on a minute. Let me see what the name of it is. But like, it's insane. This film that they're talking, that they're going to try to make the jury watch. Make them watch. Let me see. Film something in May about Alabama death row in 1970 or 80. 14 days in May. That's it. Let's watch a portion of it real quick. I'm going to give you a heavy trigger warning on this because it's absolutely just astonishing. Hold on. So you can see where we were talking about it in a previous live, and I only got through like the first maybe 30 minutes of it, and I had to stop. They actually showed the execution of a rabbit in the gas chamber in this video. I got through the first 20 minutes of it and then had to turn it off because we just could not even watch it anymore.
You see, what he does is...
And this one, by the way, portrays a man that is more than likely innocent of the crime that he's being convicted of. I'm only going to show part of it because it's just awful. I mean, and the fact that they're taking it back to like 1970s Mississippi or Alabama death row, like what? So many things have changed since then. It's insane. Watch just a couple minutes of it.
Marshal J.P. Tress Johnson's attorneys and the American Civil Liberties Union say they've got a strategy to save the inmate from execution on the 20th of May.
Woo! Gotta get right, let's leave, man. Ain't nothing but a game.
Now, when's the last time you've seen inmates work in a field?
Did you need to talk back to me? Go to hell, man. Go to hell.
Do you hear that? That officer is saying, you're talking back to me, go to hell, man, go to hell. You see, most of the inmates are of one race, and the man on the horse is of another race. I know they pick up trash on the side of the road, or used to, but I ain't seen that in years. I'm not going to play. I'm only going to play probably another minute of it. It's awful. It's awful.
Now get this new grind. Thank you, Paul. I don't need that mouth. Tell me what squad this is. What we like to do. And what we gonna do. All right, what are we? That's what I'm talking about. Snatch it on back. Get it clean this time. Ain't nothing but a game.
And that man is more than likely innocent of the crimes he's being convicted of. Oh, yeah. I'm going to play this one part where these people are talking real quick. They want to force the jury to watch this in relation to Stephen Stearns.
I
can't believe
it. One off-color remark by anybody on this staff about the execution. And just because I don't have to look forward to doing my job in this kind of situation doesn't mean that I can't be tolerant of others who perhaps look forward a little more eagerly to doing it. But they can look forward to it and still do it in a professional manner.
He is talking about people looking forward to putting somebody to death, y'all. I can't, and you want to force the jury to watch this. I can't. It's insane, y'all. Y'all have to look at them documents they're trying to pass. But anyway, and that's a good point, Abraham. No one's showing the jury how he unalived Maddie. Angola prison in LA. I've heard about it. I've heard it's not the best. Genevieve said that video is not for Stephen. It's for notoriety, recognition for his attorney. Yeah. I mean, and the man, it's obviously there's racism in that documentary. It's an old documentary. And that man is probably innocent of the crime for which he was convicted. I mean, it's insane. It's insane. At Louisiana, it might be. I knew it was one of them way down a little further south. It was a very different era back then. A lot of horrific things went on. But anyway, with that, I'm going to go for the day. I love y'all so very much. I hope that you know that. I hope that you all know that you are all very special, very important, and very loved. And I really appreciate all of you so very much. Thank you for your support. And I hope you have the best day ever. And I will see y'all tomorrow. Bye.